I like it.
Hello and a very warm welcome once again to Vestralex free online community classes on law. This is your initiative by you, for you, and possible only through the generous contribution of our seniors, guides, and mentors who take the time out to help us learn about law and legal practice and unique topics of law. So today we have again with us, actually for the first time, Shri P.S. Rajagopal sir. He's a senior advocate practicing at Karnataka. Shri Rajagopal sir has completed his MSc in physics with specialization in nuclear physics. He worked as a lecturer in physics for one academic year. Thereafter, he joined a nationalized bank as an officer. He gave up bank service to pursue law as a profession and enrolled on the rolls of Karnataka State Bar Council as an advocate in 1987. He was designated by the High Court of Karnataka as a senior advocate in 2008. His areas of specialization include constitutional law, administrative law, criminal law, revenue laws, banking laws, educational laws, commercial laws, land acquisition, and actually you'll find a lot of the information and knowledge that sir has across, I would say, platforms, which I would very sincerely recommend, specifically YouTube, that please just see topics that sir has spoken on. They're absolutely fantastic. He is actively involved in continuing legal education. He is known for his ability to break down the complicated legal propositions into simple principles of law. Also, it's absolutely a privilege to finally get the opportunity to host sir. We've been trying to get this opportunity to learn from him since a long time. But sir, we're absolutely grateful to you, and we very humbly welcome you and request you to kindly take us through this very unique proposition of law.
Sharmaji and friends, it has been 2 years since Sharmaji invited me first to talk on this platform, but somehow I could not make it. Therefore, for the first time, I am doing some useful work in vacation time. Today, the High Court vacation has started. Then I thought that there is no better way to start vacation than enriching myself by looking into laws that are applicable to private sector employment, because there is enormous literature available in the country insofar as services under the state and state sector is concerned. But when it comes to employment in private sector, the literature is mainly in the field of industrial adjudication, that is labor laws. Though there is vast segment of human resource to which the labor laws are not applicable, what you normally call as non-workman employees in private sector, there is hardly any concerted study in this branch. Therefore, I thought this would be a wonderful field to do research. And when Sharmaji suggested that I should speak on law governing private sector employment, I said to myself, where is the law? Law is only Contract Act and prohibition under the Specific Relief Act. Contract Act gives us certain rights to enforce the service contract, but all of it is annulled by Section 14 and Section 41C of the Specific Relief Act. Therefore, when I speak of law governing private sector employment, this is a field where some study in a very systematic manner has to be taken up now. Why I am emphasizing the word now for the reason. Earlier, say between 1955 and 1980, public sector employment grew at a very fast pace because our planned economy's objective was to enhance government investment in heavy industry, roads, dams, irrigation project, or what I could say as core activities of the economy. It was during that period the public sector grew not only in size, but it penetrated into various spheres of activity. What if you can imagine from Vakra project, which was those days projected as the largest irrigation and tidal power project, to Hindustan Latex producing Nirod, a unit in Kerala. Whichever area was identified as national priority required to be fostered for the long-term interest of the economy. In all those spheres, the public sector investment went in. Several corporations like Warehousing Corporation, Heavy Engineering Corporation in Ranchi, BHEL at Bhopal, throughout the country, length and breadth of the country, the public sector spread. It was that impetus given to the growth of public sector that enlarged the scope of what is meant by state. First of such judgments was rendered in the case of Madhya Pradesh State Electricity Board. We all know state electricity supply act came in the year 1948. All these electricity boards were established under the provisions of Electricity Supply Act 1948. Yet it took 20 years for the Supreme Court, a law to be laid down by the Supreme Court, which said that Madhya Pradesh Rajasthan Electricity Board is a instrumentality of state under Article 12. It is a statutory body. Therefore, the employees of Rajasthan State Electricity Board have a status. Till then, the word status is used. It was used only for government employees, because government employees have a status, whether it is state government or central government, because of Article 311. There, they cannot be reduced in rank, or they cannot be removed from office, they cannot be dismissed, except after giving them a reasonable opportunity of hearing. And that power of dismissal is vested only in the authority who appointed the civil servant. This type of protection was unknown those days to the public sector employees. For a period of time, starting from Rajasthan State Electricity Board, the constitutional protection of, what is the protection that I am asking? Protection means fairness in dealing with the employee. The law developed to such an extent. In UP Warehousing Corporation's case, Justice Chinnapreddy said, well, the employees of these instrumentalities of state may not be employees of the state itself, but I do not find any reason why I should deny them the protection of Articles 14 and 16. It is very important. 14 is fairness in action. 16 is fairness in employment-related actions. After all, the Article 16 was those days viewed as a species of Article 14, while Article 14 was equality was applicable to every sphere of activity. 16 was specific to the service law. That is how the law evolved. And from at that stage, we stopped evolving, because Vice Degree College came, Executive Committee, Vice Degree College. Then they said, contract of employment cannot be enforced, specifically because of the bar under Specific Relief Act. Section 14C, read with Section 14D of the Specific Relief Act, prohibit enforcement of a contract which is so dependent on the personal qualifications of the parties that the court cannot enforce specific performance of its material terms. And in 2018, specifically fact was amended. What did the amendment say? Till now, the enforcement of contract has been a discretionary relief being granted to the courts. Henceforth, enforce specific performance must be the rule, and decree denying specific performance must be an exception. Most of us get swayed by the headlines. I also was one of them. Reading in the morning newspaper that now enforcement of the specific performance of contract is the rule and non-enforcement is exception. I was very happy that at least the working class in this country have got some parliamentary support. But when I read it, when it came to service contracts or contract of personal service, there is no change made. Yet in one case, I could persuade the court say that look at the liberalized objective of specific performance. I could persuade the single judge of our High Court to accept my contention and grant an injunction. But my joy was short-lived because though the management did not go in appeal, when its enforcement came, and when I approached the division bench in contract in contempt jurisdiction, the division bench simply refused to entertain the contempt petition, saying that you have got a wrong order from a good judge, but we don't want to be parties to enforce it. And this is how the specifically fact is one aspect which plays its largest role in private sector employment. What it simpliciter says is, what it says simpliciter is, no contract of personal service can be enforced by a decree of specific performance. And correspondingly, even in section 41 dealing with injunctions, it says, when injunction is refused, an injunction cannot be granted to prevent the breach of a contract, the performance of which would not be specifically enforced. Therefore, if you cannot get a remedial decree, you can also not get a preventive injunction. Therefore, insofar as enforcement of personal contract of service is concerned, law is simple. Contract law applies. That is what the Supreme Court said in Swarankar versus Bank of India. We do not accept the theory that contract act would not apply to contracts of service. It applies. But the distinction they make is in the matter of remedy. While in respect of employments governed by public law element, you can seek a declaration that termination of employment is bad, and therefore it is declared because the termination was bad, he continues to be in employment. That is the declaration I can get under public law. But contract act, contract being a private law or contract being a relationship that is governed by consent between the two parties by a contractual instrument, it is not specifically enforced. And the relief or remedy for you is to seek damages for wrongful termination of the contract. This is a fundamental difference we have to understand between employment under a state or instrumentality of state and employment in private sector. First thing is, the private sector employees should be entitled only for damages for wrongful termination of the contract and not specific performance of the contract. But there are exceptions. Exceptions to enforcement, the non-enforceability of performance of service contract or contract of personal services. Industrial Disputes Act. Industrial Disputes Act is one enactment which enables the industrial code to create new contract between the parties. Industrial law is aimed at protecting the weaker section. Weaker section means there are two parties involved in any industrial dispute: management and workman. Management is always treated as dominant party, and worker is always treated as a weaker party. Therefore, this industrial legislation, several industrial legislations are there. Industrial Disputes Act, Industrial Employment Standing Orders Act, then Contract Labor Regulation and Abolition Act. Several such enactments have come. Provident for Employees Provident Fund, Miscellaneous Provisions Act. All of them apply to work and not to those who are not workmen. I would not call them as managers because most of them are not managers. I have a very distinct definition of the word manager in my vocabulary. You won't find this meaning in any of the law dictionaries, nor any Oxford or Chambers dictionary. My definition of manager is something totally unique. It is modeled on United Nations Convention on Professional and Managerial Employees. What that convention says is, to be really a manager, a person should have power to hire and fire. He should be having power to appoint or power to terminate. Without this, you are not a manager, you are a conveyor. What the workmen tell you or what the workmen do, if it is not to your liking, you convey it to the management. Management takes action as it deems fit. I always say that 98% of non-workmen staff employed in the country, they cannot be really called managers. They can only be called, as in Victorian era, a manager of State Bank of India branch was called as agent. He is the agent of the management and nothing more than that. Now we have given them a glorified designation as manager. Now all these persons who are not workmen are generally called as managers, which I think is a wrong connotation. They can be called only as non-workmen employees. They are still employees. They are not workmen. But workmen's contract, service contract can be enforced through the Industrial Disputes Act because under Section 11 capital A, the Industrial Court has power to reinstate a wrongfully terminated employee or even restore the status of a wrongfully reverted employee. Whereas in case of private sector employment, it does not happen. Only thing is we will get the damages. Damages also what we get at the end of 10 years or 12 years or 20 years of fight, because the matter has to start from civil court to high court, or civil court to district court to high court to Supreme Court. It will take minimum 20 years because that is what the normal period of transit period or travel time for a civil dispute to be settled in Supreme Court. 20 years should have slot, and ultimately what you get as compensation is maximum you may get about 2 years or 3 years salary, because one principle of law that is applicable in damage determination or quantification of damages is that the employee who loses the job, he has to make every effort to mitigate the damage. That is, he should try to get alternate employment, or he should try to get himself rehabilitated in life. And after such rehabilitation, what is the loss you have incurred? Quantification of it is made, and that is awarded to you as damage. If you don't try to rehabilitate and mitigate the damages, you will not even get a reasonable damage or damages, because All right, you must have be happy with not being employed because you did not make any effort to mitigate the damage. However, this is a very sad state of affairs, but there are certain good aspects. For example, one constitutional protection that is available even to a private sector employee is that is begal or forced labor. Suppose a private sector employee wants to resign from service. If the resignation is unreasonably withheld, that amounts to forced labor, which apart from being a constitutional right, begal, it is also a human right. When it comes to human right can be enforced even in private employment. And then we have any contracts of service, any number of contracts of service where they say you will be sent for 1 year training abroad. You have to come, after coming back, you have to work at the employer for 10 years. Otherwise, quantified damages. In such cases, the courts have interfered even in respect of private sector employment because two fundamental principles will be applicable there also. First principle is the employer being a party to contract cannot unilaterally say that employee has breached the contract. Even the employer is required to go to civil court and prove that employee has breached the contract. Then damages, the principles that are generally applicable to any other law would be applicable. And it would not be, in such cases, the cost of the training undergone, the cost incurred by the employer for the training that has undergone. But over a period of time, there are certain areas of employment, even in private sector, which are being protected by law. For example, teachers. Teachers' service issues under the dispensation of TMFI Foundation, larger by judgment of the Supreme Court. It said that teachers in a private college, private educational institution, their employment is a matter of contract. It is a contractual employer-employee relation. But at the same time, in TMFI judgment, an observation was also made. A special tribunal should be constituted for looking into the grievances of the teachers. Wherever there are no such tribunals, a court headed by district judge can be made a tribunal like. But there were states even at that time, notably two states. One is Delhi, though it was a union territory. Then there was one Delhi School Education Act 1973 was there in Delhi. And in Karnataka, we had Private Educational Institutions Discipline and Appeal Act 1975. Under these two enactments, any order of punishment imposed by the institution, educational institution, let it be even unaided, aided, minority, there is no exception. Any educational institution, if a teacher is dismissed or unfairly treated by imposition of any lesser penalty or loss of seniority, he can approach educational appellate tribunal, which is headed by a district. And the educational appellate tribunal is lawfully so constituted that it has power to annul, modify, or impose a punishment as it thinks fit to the teacher. Therefore, a teacher in the states of Delhi, in Karnataka, and in some other states, though in private employment, he can be restored to service. Their declaration that contract of service is subsisting, its termination is bad, it is subsisting. Consequently, he shall be treated as if the contract was never snapped such a relief is available. Whereas in Bombay state or Maharashtra, even now such an enactment has not been. There is a administrative body set up by the government. Some Sikshak, some body is there. That has been held to be an advisory body which will make its recommendations to the state government. That is, from bad private management, the case of the employee will go to the indifferent government establishment. And whatever government decides, that is it. Therefore, specific performance of contract of employment, notwithstanding what is contained in the specific relief act, can be enabled by appropriate legislative measure. One area where such legislative measures have been taken is in the field of education, because teachers constitute a vast segment. And one good thing about it is now education is covered by entry 25 in the concurrent list and then state list, and then it is subject to law made by the parliament, because higher education, professional education comes under the parliamentary enactments. One good thing about these enactments is, even though they are made by state, for example, in my own state, Karnataka Education Act they have made subsequent to 1975 Act. They made another act in replacement of that is called as Karnataka Education Act 1983. In that act, to keep itself within the limits of its legislative competence, what the state legislature has said is that it has provided a detailed operating procedure as to how disciplinary action has to be taken. If disciplinary act, if a teacher suffers a punishment, he can go to educational appellate tribunal, and the educational appellate tribunal has all the powers akin to the labor code. That is, what are the powers of the labor code? Labor code, particularly when a matter goes in respect of a disciplinary proceedings taken against a workman. First issue they frame is whether the inquiry held by the management is fair and proper. If it is held to be unfair, then instead of remitting the matter back to the employer, the industrial court itself will conduct the inquiry. Then it can order reinstatement or whatever award it wants to pass in the facts of the case. Therefore, such a law is now available, at least in some of the states, even in respect of teachers. Then there is another major employer in private sector. I am touching those aspects where every village will have such type of employment. For example, teacher. There will be a teacher in every village, or at least that is what our objective. We want to be a welfare state. We want to take school to the house of every rural child. If that is kept in mind, there will be a school in every village. And at least teacher in a village is protected by this Education Act, by this education appellate tribunals. Justice Chinnapreddy, in fact, in I think Saint Anthony's public school case, which arose under the 1973 Delhi School Education Act, he said that was concerning a minority education institute. He said so categorically that minorities have a right to administer their institutions. Right to manage does not include right to mismanage. Of course, such a distinction had been made earlier in Ahmedabad St. Xavier's, thereafter, I think, when Lily Thomas or regarding Kerala education, there was a judgment of the Supreme Court. Therefore, now, the protection to non-workman teachers has come about by way of Education Acts in some states. In most of the states, it is yet to come. Then every year every village will have one cooperative society at least. It can be farmers cooperative. It can be milk producers cooperative, or it can be even say poultry cooperative, depending upon which is the predominant activity in that segment of the country, in that part of the country. In respect of cooperative societies also, some states have evolved their cooperative societies acts in such a manner. A person who is heading the court, it could be called as court of registrar, or it could be called as arbitration by registrar, by whatever means you call, name you call it. It is not relevant. Those tribunals also have power to enforce specifically specific performance of service contract of cooperative. Still, there are large segment of the private sector employment has not been given this security of tenure, and more importantly, they are to be insulated against humiliation. If you take the private sector employment, normally how the story starts and how the story ends. Story, how it starts is not relevant, because how the love starts is irrelevant in life. We love, we marry. But the question is how the story ends. When the divorce comes, it should not enter in bitterness. But that is exactly what is happening in private sector. A person is humiliated to test whether, being unable to bear humiliation, he will resign and go. What is the humiliation? He is given low performance rating, meaning low annual increase, meaning retardation in career progression. He says, person whom I am training, they are growing faster. I am not growing. Let me say goodbye. No, my financial position does not permit me to say goodbye. I'll bear this humiliation because I have to leave. Two things are required in private sector employment. One is insulation against humiliation and security of team. The one way is to humiliate him and see whether he. Otherwise, another way is, I would say, gas chamber method. What is the gas chamber? Unannounced, you will be called for a meeting with vigilance or whatever they call. They have got very high-flying, very attractive names. Audit committee, a vigilance committee, ethics committee, as if the private sector in this country is full of all those values. I worked in private sector also for 1 year. After leaving the bank and before becoming an advocate, I worked as finance director in private manufacturing because just I wanted to see. It is easy to, everybody says public sector is corrupt and private sector is paragon of virtue. After working for 1 year in the private sector, I felt, if at all there is a knight in shining arms in this country, it is public sector and not private sector. All these committees, ethics committee, vigilance committee, audit committee, one after another, they put the unwanted employee in one room, start high pressure questioning. Nobody will be able to withstand that. At the end of it, if you initiate action on this, you will be nowhere. Better you resign. These two are remedial managements who take the resignations after going through all this. But there are champions in resignation management. Those are the managements who take your signature on a blank sheet of paper or signed resignation letter, typed resignation letter, even at the time of joining. Like in some of the states, rent control laws are very, very strict. Now, of course, it has most of the states that has gone. They would take, the landlords would take, or advocates would make them take a possession delivery letter, undated, along with the lease agreement. So that if he goes at the end of the 10-year period to seeking protection of the rent controller, they always produce it. Look, he has voluntarily delivered me the premises. It is these high pressure tactics which the weak employee is not in a position to bear. This protection is required. One effort was made in the short-lived Janata government between 77 and 80, I think. It was there for hardly 19 months or 20 months or 3 years. Ravindra Verma, who was a labor minister in the Janata government, he introduced a bill in Lok Sabha, in the parliament, that managerial employees, security of tenure and miscellaneous provisions bill, 44 years ago. Government fell, bill fell, thereby became extinct. Thereafter, governments of every few have come in this country. Every color, you name the color, that government has come. Labor ministers of every economic philosophy has come. Nobody has tried to do it. I think between 1990 and 2015, almost 2015, nobody felt need for security of tenure because economy was growing because of liberalization. These job opportunities were many. The experienced manpower was less. Therefore, security of tenure was not a big issue. Now again, security of tenure is raising its head because growth has retarded. I'm not going to percentages because percentages can always be convenient figures. Suppose inflation is too high. Easiest way of controlling inflation is shift the base year. If it is 1960, index level will be some 2000. Make it 2000 so that index will come down to 600. Make it 2024, it becomes 100. I don't want to go into statistics of numerical figures, but any sane person, when we go around, of course, these days we have stopped going around. Because earlier the faith was, if you meet people, you would understand the society. Today we have no patience to meet people. Today we never go around the market. We order online. 1 kg baingan bhejo, tomato bhejo, all these things we order online. Therefore, we do not know the conditions in which a nooked seller is living these days. Merely because he says you can make payment on phone pay, we think he is rich and he is happy. But time has now come that, again, all right thinking people, particularly the advocates, because always remember, the advocates have a great role to play. More than 50% of the freedom fighters were advocates. Today we feel so frightened even to exert our own freedom. There are advocates who say, sir, can I tell this to court? I always tell them, if you cannot exercise your freedom of speech, why do you take wakalat to exercise freedom of action of some individual and kill him also along with your silence? Jo bolna hai, wo bol the court. You may be right or wrong. Let the judge say that you are wrong. Why do you think that your client is wrong? These are this private service law regarding private sector is today, it requires immediate repairs so that the society gets ready for the next recession or for the next cycle of unemployment or next cycle of excess manpower with reduced job opportunities. Today, what has happened is any newspaper you see, every state government and also state government, central government, 50% of the sanctioned posts are vacant. Today, I saw in the newspaper, Karnataka state government, some 2,65,000 or something is at the vacant posts. Total number of posts sanctioned may be around 6 lakhs. This may 2,65,000 if they are vacant. We can understand what is the rate the employment generation is growing in government. If that is the government, then what happened? What happens in banks? Banks was another major public sector employer with the computerization and then all the your what is that banking, mobile banking, and then another what is this Google Pay. Banking employment has now come down to 20%. If you see the banking sector, therefore, shortly or almost we might have already reached that stage. We are staring at loss of jobs. Loss of jobs means there are two effects: employment growth and curtailment of employees' existence by way of unwarranted retrenchments, terminations, all these things. Therefore, as on today, we are eligible only for damages. And damages really do not quantitatively, they do not compensate for the loss of job. The principle of restitution is applied. The damages these civil courts would grant in case of service disputes are peanuts. But there is immediate need for waking up and making noises so that the law changes. Because if we may start making noise today, we know when it is going to change. And noise should be consistent and should be loud enough to be heard. Unfortunately, we as advocates have lost touch with the ground realities because we go by cars, we argue online, we uh, very rarely meet the clients. Particularly as senior advocate, there is one suffocation I feel because I am prohibited from meeting the client. I have to meet only the advocate. What reality perception I get? I am grateful to you, Sharmaji. I told what is one there is before just one thing. But there are certain acts which are applicable even to the private employment. That is payment of gratuity. With the removal of ceiling on salary in the wage limit in payment of gratuity act is applicable. But the Employees Provident Fund Act also is applicable, but it is voluntary because within the wage limits stated in the Provident Fund Act, it is compulsory. For those employees who are above the wage ceiling prescribed under the Provident Fund Act, coverage under PF Act is voluntary. One compulsorily gratuity act is applicable to everybody. When Supreme Court said that teachers are not eligible for gratuity under the Payment of Gratuity Act, Parliament very soon rectified the defect in the act with retrospective effect that is applicable to even private employment and PF voluntary. Otherwise, no labor law is applicable because of artificial thinking of what is workman, what is manager. Non-workman employees, if you want to create a category, but bring them under that act. And the rest, it is only contract act, non-enforceability, and damages. These are the only three words I would like to say about the private sector. Thank you, Sharmaji.
So it's very kind of you, sir, for your obviously humble words, but most importantly, sir, for actually just demystifying the entire sphere of the law governing private sector employees or employment. Because sir, actually, I don't. I'm very grateful to you, sir. You actually simplified it in 3 words. That's the best that could have happened. If there is nothing more, then there is nothing more. So, but sir, also I'm grateful to you for sharing your thoughts and insights. I'm certain that these will necessarily help in uh, all your suggestions. Also, I think with respect to raising the voice, also I think these are the kind of things which, unless are done in courts and through the appropriate mechanisms, that they will necessarily only lead to better employment status and opportunities for people and good conditions for everyone in the country. So it's a humble and it's a fantastic thought, sir. And obviously, all of us, our support is there with you, and we're grateful to you for enlightening us also that there are such things that we need to be more concerned about. So I request everyone that whatever your questions are, please just raise your hands at any point of time whenever you want to ask them. In the meanwhile, I'll keep asking my questions, and you can share them in the chat box also, whatever is convenient. So, sir, one question that I wanted to ask you was in the private sector also between the categorized sector and the uncategorized sector. Is there any difference specifically in the kind of remedies that may be available to them?
See whether the certain specified sectors, as I was telling about the cooperative sector and teachers in education institutions, specific remedies are being provided by different states, which can result in enforcement of this. This organized sector and unorganized sector does not play very much role in these matters because the moment you are not a workman, you cannot raise an industrial dispute, be any sector. Once you cannot raise an industrial dispute, either regarding anything, then whether it is an organized sector or unorganized sector, it doesn't matter much because it will be an individual dispute which you can agitate only before the civil court. But real problems come in case of agriculture sector. In agricultural sector also, there are employees who are like say farm manager. Now with the new technology seeping into agriculture also, it is good. I am not saying that it is something to be avoided. It is required to increase productivity. There are also these non-workman employees. That is actually one who does not till, but who manages the tillers. That category, they again fall into this being non-workman employees in agricultural sector, who will have to come to the civil court only to claim damages. And you can imagine the fate of that person. If in a sowing season he has to attend the court 3 days, his future employment also is gone. Therefore, the irrespective of the sector is organized or not organized, as long as there is no segment specific law which enables enforcement of contract of service, the position would be same irrespective whether you are here or there. That way, the these days courts have also changed the view of who is a workman, who is not a workman. Just about 10-15 days back, you must have seen a judgment of the Supreme Court, which said that with the economic changes that have come up, we should have economic realities in mind while interpreting the word work. So there was a definition of workman in Industrial Disputes Act has not undergone a change. It has remained the same. At one point of time, when wages were low and airline pilots were supposed to be amongst the best paid jobs in the country, They were declared to be work by interpretation of work content and absence of discretion. He was treated as a work. Today, almost every software engineer, he is not treated as a work because the days where Supreme Court said you should look to the job content and not job title. That is slowly vanishing. There will be three software engineers. One of them will be called team head. What is team head? He guides the other two. Team head is not a workman. I have also argued and succeeded, unfortunately. Team head is not a workman. Therefore, you can create a team of two, make one of them headless by saying that he is team head, therefore he is not a workman. And when it came to protected work, a division bench of my High Court says industrial laws were not meant to protect such type of high salary drawing workers. All right, those days, 200 rupees might have been the salary. But for foreigners, I was getting a full meal also. Why your inflationary looks at my salary only and not my needs? This is the problem of our not going out and walking on the streets.
So I pray that this initiative, and I request everyone, guys. So this is what I think is the reason why Sir, thinks better to be with us. So this is the opportunity that whatever your thoughts are, uh, यार देखो इस इनिशिएटिव का सिर्फ एक ही एलिमेंट है सबके लिए कि यहाँ पर हमें मौका मिलता है सर से आके बात कर पाने का जो भी हमारे सवाल है जैसे सर ने बोला कोर्ट में तुम जज के सामने खड़े हो इफ यू हैव अ क्वेश्चन इफ यू हैव अ डाउट इट मे बी सिली इन योर माइंड आपको शायद लग रहा होगा ये मैं कैसे पूछूंगा या क्या ख्याल है लेकिन अगर हम उस मौके पे वो बात नहीं बोलेंगे जो हमारे दिमाग में आती है जो ख्याल है तो वो रह जाता है हमेशा so this is our basically initiate the basic idea behind the concept is that first we get to hear from you, and then there is an interaction also. And sometimes it's absolutely up to people जिसका जो मन में ख्याल आता है सर मेरे को तो बहुत सारे सवाल है मेरे अपने खुद के to be very honest with you because I've seen I've also worked in the private sector and जैसे सर लॉ प्रैक्टिस करने का मुझे मौका मिला at diverse places private sector भी I got to do a lot of internships actually I did a lot then small jobs I got here and there so I got to see and with the best companies. I worked with Porsche India, Procter and Gamble India. Like I on with their teams in manners. I got to do a different kind of work. So I have some idea of the kind of things which you mentioned that how employees are when it's like a funnel that whenever they want to throw them out, it's a very systematic manner and procedure and the kind of things which you mentioned, sir. They hit right at the heart of it that there is humiliation which is created that there is a manner in which systematically people are brought to that place that they think that oh I think it's better that I resign only or I should start looking for new options so is there any safety in is there any job security in private companies
Law security of tenure is not there. But security is if you ask me in financial terms, there is no security, only damages. Damage is a fraction of what you actually suffer. That is where I always have felt, and I have been canvassing for the last 50 years, that non-workman employees have been ignored for too long in this country. There is absolutely no security for them. Only security is a strong nerve, nothing else.
is that why all those things like chatukarita and all are considered to be very important for people working in private sector employment that you have to kind of suck up to the boss, otherwise your job is at jeopardy.
Yes. And today, ultimately, what happens? Look at their fate. This is happening in some of the uh, infotech giants, even in GST or whatever it is. Top management to retain a client, they advise the lower level functionaries to manipulate, particularly in the matter of invoicing or accounting. For everything you have a ready-made solution. For accounts, tally is there. For something else is there. You want to get food, we have Swiggy. I don't know in Delhi what is this.
The same thing.
Swiggy is there. The top persons, they say that in this account, we have to manipulate. There will be no written instruction. When ED comes, and these days it comes too frequent. When ED comes, it is the system manager who is sent to jail, not the person who instructed him. And higher person, because he is the capitalist, he doesn't need any protection. This person who manipulated, he would have earned 1 or 2 promotions to show that, to make him feel that this management has confidence in me, it will support me. When it is most needed, it will not support. This is the real problem is you cannot be a vigilante in private sector.
Absolutely, sir. Absolutely.
Absolutely. Second is, even in your defense, if you speak, nobody will believe. Because we would have gone in that line so ahead that nobody will believe you that it was not a path charted by you. You cannot say that I followed somebody's path.
So,
Everybody will believe that you charted that wrong path. Therefore, you are being rightly put to face the punishment.
certainly, sir. But I find this very relevant, I think, in all spheres of life. What you just said, that there cannot be any vigilantism. At the same time, you have to comply. I think everyone, any employer primarily, I think, looks for this only in an employment. I'm really very interested and intrigued to learn about international private sector working conditions and all, where you have minimum wages and all. And then I want to have some sort of a comparative analysis with respect to India. And so that is, I think, how possibly if we draw on some
Yes.
international good ethics and practices, we can lead to some kind of positive change here. So just few final questions. So we've already completed the time that you had promised. But a few, if you'll indulge, so if you'll permit.
Please.
All right. So, sir, one thing, so since we mentioned a very interesting thing that you mentioned, that we were discussing food delivery apps. So similarly, let's assume some kind of food delivery apps or some kind of BPOs which employ a large number of people on the ground. Or let's keep it to food delivery. So we get in the ambit of startups. So anyone working for a startup with at a low level employment, such as these guys who are going out and handing out food packages and all. So what are is and they would be earning around 25,000, 30,000 rupees, I think, and some incentives and all. So what kind of do they have any kind of recourse, sir, if one fine day one guy just gets a message that, oh, you don't have to come from tomorrow?
They are not even treated as employees. See, most of them are treated as service partners. There is no employer-employee relationship. Their existence of employer-employee relationship is the foundation for any your uh, seeking a protection. They are treated as independent contractors. The moment they are treated as independent contractors, The whole concept of employment law collapses there. They are called as, in fact, this one, yesterday I was told there are any number of now cab aggregators, particularly from airports.
So,
My son-in-law was telling me that all the cars are owned by the aggregator himself. Drivers are employed as drivers. Factually, it may be true, but legally, they are treated as some say airport journey partners or something like that. They are partners. The basic concept is, see, old judgment one. There is one old judgment of Kerala where the question of section 120 capital B came, the old IPC, criminal conspiracy.
yeah.
Now there is a manager, there is a clerk, there is a deputy general manager. Allegation against this clerk was, you have entered into a criminal conspiracy with your general manager, deputy general manager, everything. Kerala High Court acquitted him. Do you know what is the reason it gave? A clerk can never conspire with the DGM. He might have at best, the only allegation, the only misconduct I can attribute to this employee is he did not bark when it was his turn to bark. He remained silent. Now, if you call driver a partner with the owner, it reminds me only of that judgment and nothing else. Partnership can be amongst equals or near equals. Now, what is the foundation of Section 23 of the Contract Act? Unconscionable terms in contract. Go to judgment of Supreme Court in Brajanath Ganguly versus this Central Inland Water Transport Corporation. There was a contract of service signed by both the officer and the management. It said, it was a public sector organization. It said, contract of employment can be put to an end with 3 months notice on either side. It is naked, hire and fire. The argument of the corporation was, look, we have negotiated and entered into this contract. He has also signed, corporation has also signed. We had equal opportunity not to enter into this contract. Then Justice Madan, speaking for the Supreme Court, said, equality that you are speaking of is like equality between lamb and lion. Both roam about in the forest and both have freedom to devour the another. But who can devour, everybody knows.
Absolutely, sir. It's very it's actually, sir, I think, so I'm very grateful to you, sir, for kindly taking up this topic and explaining to us so much in depth as to what exactly is the harsh reality of the private sector today. Sir, if what I understand, sir, as of right now, is that if anyone is given a notice, let's assume if it is mentioned in the contract that if anyone is given that a person may be asked to leave their job on 3 months' notice, so that's absolutely valid. That any
That is
at any
valid.
simply
It is
because of the
valid.
fact.
Yes. Only in
Simply
those
because of
cases
that.
that if the contract of employment contains the term, it is valid because protection of Article 14 will not be available to him because he is a private sector employee. But these days, managements are still very enlightened. When it comes to issuing notice, they would not issue a notice. In lieu of notice, they will attach to the letter of termination the notice pay and send it to you.
Together. As a
Most of
separate.
the time, this in the mistaken notion, if I take that notice pay, I will be accepting termination of contract. The employee will not encash the check also. Then he goes to the civil court. Civil court does not give him any relief also because it is strictly in accordance with the terms of contract. So uska notice pay also he forgoes, employment also he forgoes. That is the position that is prevailing.
So what about legal? What about bonds that, as you mentioned, that if someone is sent internationally, then they have to come back, or probably if someone signs a bond that I will be working for this company for 1 year after engaging, then sir, what is the treatment of that?
There, see, the court is entitled, civil court is entitled to look into whether the employer himself created a situation where this employee could not serve the bond period. There may be. Secondly, if it was case of forced exit because of actions of the management, then also the claim for damages could be successfully resisted. Then third is quantification of damage. Whether damage claimed is reasonable. Of course, there are 2, 3 tests. One is the specified damages, simplicity without anything more. Third is proving it to be unconscionable. And unconscionable contract now, whether it is private or public sector, it applies to everybody. After the judgment of Supreme Court in Central Inland Water Transport Corporation case, the section 23 is being applied liberally by the courts. But only thing is, what relief you will get is the question. Even where you are unconscionably terminated, you cannot be reinstated in private employment. That is where ultimately it boils down to that. But even where you leave the service without serving the bond period, successfully, to a large extent, we can resist the claim for them. It is possible, but we should have time and patience. And in the youth of your life, you will not be having that time.
So certain.
Therefore, you would like to pay it off and close the chapter rather than resisting it. It is a life situation. Take the case of a professional who is aged about 35 to 40. At that age, if he has to fight litigation, instead of furthering his career,
Yes, sir.
what would we have?
So
We will
this,
have a posthumous Paramveer check to be awarded to him.
so
He
the
is
same,
success.
so this same advice I try to give at least all any clients who come to me, specifically in matrimonial matters. That please, this is the age when you're trying to, and so women also, and I think I don't know why these people are suggested sometimes to quit their jobs so that they can get some kind of respite. And I go like, are you crazy? You earn more money, you pay off. Where does it matter, right? You pay it off. It's your family only. Howsoever, you'll always be attached, no matter what you can do. So, but sir, again, so I'm sorry, sir. So, in lighter vein, if you'll permit me with respect to our topic only, sir, I solicit one advice from you, right? This is a very long time back it happened, but the circumstances were so unique that they just get stuck in my mind. And every time I try to contemplate that, what should be the advice now for the employer, not for the employee, but for in the interest of the employer. So, one friend of mine, sir, and this is a conversation of I think about at least 5, 6 years back. So he calls me one day and he tells me that Keshav, I have a problem. I go like, what happened? So he tells me that one of my employees, at like he was a errand boy running around doing things. So he goes like, and this is in Bombay. So he goes like, one day he just got very frustrated, and he called me and he told me that I am lying on the railway track at Bombay, one of the railway stations. He goes like, I will give my life today. Right? And issue he had. So he was very fanatic, this guy who was the employee. He was like, ऐसी कोई बात नहीं. He was like, I scolded him a little. Again, that's undoubtedly that's true. But Keshav, what do I do in this circumstance? So, sir, what would if had you been Keshav, sir, what advice would have you given him in this situation?
What can I say? To save your skin, you will have to tell the railway police and saying that to prevent it. Otherwise, what happens is, in these days of call records being available, they may even say you frustrated him so much he has to commit suicide.
Absolutely, sir. I was so scared, sir. Thankfully, nothing happened in that case. Like that guy I think, hopefully he's still also well, but that day at least nothing happened. And he continued working for some time. So just one final thought on this line itself. So, answer with respect to the entire conversation that we've had so far, and I'm really very grateful to everyone else who's also still with us. But we've exceeded Sir's time. I'm just taking liberties right now because Sir is also permitting, and you guys are also so kind. So just one final question with respect to mental health. Uh, since you mentioned all the harassment which is there, the kind of things as gas chambering and all of these concepts which are there through which these employees are put through, and then they again the concept that there is no safety or security of the financially, there's no security per se. Then your personal aspirations, ambitions, they are there, which I don't think that every person gets to fulfill or live through their whatever jobs they are doing. And again, then there are things like workplace harassment of various sorts, not just
Yes.
necessarily the posh one. So uh, so how exactly do you think is mental health, what is the relevance of that? Do you think it is being adequately taken care of by all of these people, and is there anything that can be done in that respect or should be done?
Mental health, I feel, is being ignored by the present corporate sector. If you see the working hours, unregulated working, the working span in the matter of number of years is, you just take the case of the present, this, not many software engineers find it comfortable to work beyond the age of 48 to 50 because see the high pressure work atmosphere in which they are delivering their. I know some of them working for 20 hours a day. I know some of them eating, food intake also is while they are on the laptop. See, simplest thing. If you don't enjoy your cup of coffee and gulp it, that itself is a disorder. Because everything, every human activity is designed to be done in a particular manner. Not because it is fashion to do so, but because for each activity, work, talk, newspaper reading, including your WhatsApp browsing, beyond a limit, it is not good. And below a point, it is equally bad. This balance, mental balance, can be maintained. Why do we pray in the morning? Not because we have seen the heaven and our path is being laid to go to heaven. No, it is a diversion from daily routine for you to think, if not of God, at least of what has been done, what remains to be done, to lead a sane life. I advise even non believers to pray. I will tell them, don't pray to God and all. You sit in a corner. All right, if you don't want to have photograph of God, remove it. If you want to have photograph of your girlfriend, have it. But don't think of God, don't think of girlfriend. Sit before that photograph so that you are alone. Think what you plan to do, what you have done, whether what you have done is in right time. Even to think that much if you don't have time. It is a case for mental checkup. After 6 months or 1 year, it is bound to affect your reflexes, your performance, and even your physical and mental stamina. If any of these shrink, that becomes a case of mental imbalance. We have to have regulated working hours. We have to have time for taking our thoughts away from. It cannot be called as whiling away time. Nature has created all these activities for a purpose, and that purpose is you and you only. For your survival only, nature has done all these things. Why do you like to work, or why do you not yourself align with the nature? What is alignment with the nature? Night we have to sleep. Then before a particular time, we have to get up, because that is when the birds all start getting up. After a time, we should not be awake. That is when the owls awake. These are made not for fun. They are made for a purpose. Purpose is to have life with enjoyment. Any one of these suffering, mental health will be affected. How the mental health it shows up? Getting angry for nothing. You keep a cup of water in your coffee time, you will drink it as if even without realizing. Today, office boy has not kept coffee here, he has kept water. Sometimes there are good office boys also, fun loving, and they say, क्या साहब मैंने पानी रख दिया कॉफी करके पी लिया उसके. See, these are the signals, these are the alarms, and those bells ring for us, and we think it is for neighbor and not for me. It work life, the work situation is such that mental health is disturbed. I would be pretending if I say that no, it is not getting.
So would it be in any manner constructive or conducive if, say, something like a POSH Act, the Gender Sensitization Committee, which is there, if, let's say, that committee, the scope of that committee expands. So I got to work a lot on the POSH Act. I got idea of what the legal domain was with respect to the Sexual Harassment of Women at Workplace Prevention Prohibition Redressal Act 2013. So I was associated with an NGO then, and they were doing some awareness. From 2014 itself, I started reading it and got to learn about it. A little bit of the interplay between that committee and how that organization is supposed to work, responsibilities of the employer, the kind of things that they are supposed to give to the committee per se. So now my thought, sir, is, and sir, this is something I've been considering this for some time, but since I just heard your views and I just could not, how do I say, restrain myself, and I thought that it would be best to take your advice on this thought, that if the ambit of that particular committee, because it is already mandatorily being formed, and I remember, sir, at that point of time, private companies, they don't care, sir. The only better thing is that there is a mandatory obligation under that particular act. It mentions very specifically the kind of obligation that you have to post it on these things. You have to, make that committee very visible, and everyone should know about it. And that's the only reason why these people have done it. Initially, I remember, so the biggest companies, they would just throw it on my face. They would be like, "Oh, what, we have the Vishaka committee." But now, since this mechanism is in place, and I think thankfully it is somewhat there, because everyone speaks about it. I get to know about it from everyone who's working in the private sphere, that they're aware of this. Definitely sexual harassment is one aspect, but the more people will, I think, a lot will, it will help in domain of that also. If it is further, that if people are mentally, if they're stable, they're happy with their families, they're happy with their life, with their work, then automatically, I don't think anyone would want to indulge in any such activity which would further, be to the detriment of anyone else. But if such a thing is done, and so I request, I've been thinking of a PIL on this since 2018. I think 19, but then COVID came, everything went off track. But and to everyone else also, it's a thought. Please, आपको suggestions देना है इस पे. So I think it is most valuable. So I read this report, two reports for that matter of fact, by ICMR and by Gates Foundation, and in collaboration also. Both of these said that around 15% of Indian people are under some kind of mental health issues and worries. I try to translate that into numbers that goes to about 20, more than 20 crore people in India need some kind of therapy or need some kind of, how do I say, at least some kind of love, affection, whatever it may be, but they need to be reassured and self-assured. 20 crore people, so that is our resources, which is absolute. And one person in one family, that impacts three people directly. So it directly goes to 80 crore people. This is, I think, one of the biggest and the most pressing issues. I sir, also, sir, I'll just, since you've indulged me so much, I sent a letter, I wrote an email, I sent it to every single parliamentarian in the country. This happened when Sushant Singh died. That guy, he had fame, he had money, he had influence, yet he chose to, or whatever may have happened, I don't know much about the criminal conspiracy that was being floated, but that guy, whatever happened and whatever is there in the domain, and irrespective many other such people who have money and lots of things, that guy from Cafe Coffee Day, so many people, sir, they end up doing going on, whatever path. At least their families are also impacted. Everyone's impacted. There's the least that can be done, and I think, sir, it should be considered, and I think that there should be, at least, sir, you may kindly issue notice. Let's assume this to be a moot court, and sir, I request you that this is my prayer that uh, such and such POSH committee, internal committee, should also be in charge of dealing with complaints with respect to complaints, issues, and all these HRs and all. There should be an obligation of spreading the thought of mental health in their companies.
That is required. This is because every abnormality in behavior is attributable to some mental uh, ailment aspect of that. That is my personal view. Of course, in law, how it translates, we have to see. Right then, Sharma ji.
Very, very grateful to you, sir. Very, very grateful to you for the extended discussion, and sir, for also for being so kind to let me also just go with the flow and express these thoughts. So, humblest gratitude to you. And thank you so much, sir, for, I think, anyone who would refer to this particular video in the future also, they would at least get to have a very real world outlook and overview of what exactly are their rights when they're working in the private domain. At the same time, what are the kind of challenges that they should be concerned about while they're working for it. So I'll recommend it to everyone and say it's humblest,
Thank
very, very kind of you, sir, to be so
Thank you
considerate.
very much.
So I seek your permission to end the class.
Please.